Darnell D.
Thank you.
Ms. O'Brien?
Good morning, Your Honors. As you know, this case involves a charge of receiving a stolen motor vehicle where the defendant was a passenger in this vehicle. And I've made two arguments. One is that the evidence did not support a conviction in this case, essentially that the defendant's motion for required findings should have been allowed.
May I just interrupt just to get some
Yes.
background on the facts? The defendant was sitting in the passenger seat, correct?
Yes.
And as I understand it, he at some point saw the police, turned suddenly, got in the car, and the car sped off.
No, Your Honor. I believe the facts in this case were that the defendant was a passenger in the vehicle, and at some point they stopped the vehicle and another person got into the vehicle, a fourth person, an African-American person, and they continued to drive, and they are alleging that it was the defendant who turned to glance to see what was behind them and continued on a little bit further, and then at some point the car stopped and this passenger got out of the vehicle and ran. Yes.
Now, in terms of additional facts, was there any evidence regarding the car itself? Was there the popped ignition, the screwdriver, and the...
There was absolutely no evidence.
No evidence.
No, and even the victim testified that he had his doors locked. He didn't see anything on the outside of the door. There was no broken windshield, broken window.
Well, let me ask it this way. When they finally when the police got to the car, were there keys in the car?
There were no keys in the car. That's what the officer testified to. The victim brought his keys to the scene and shut the car off. But all the testimony at trial from both the police officer and from the victim was that they don't know how it started. There was no evidence of wires hanging out or the steering column wasn't broken. There were no keys in the car.
But it was going without keys.
Exactly.
Okay.
Exactly.
Left going.
So this gentleman
Yes.
is sitting in the passenger seat, and the car is going, and he looks to his left, and there's no keys in it.
Well, Your Honor, I would argue that most people don't look to see if there's a key in ignition when
But
somebody picks them up.
even if he did, that would show recently stolen property. But how is the juvenile in possession or control of the property?
Well, that's one of my arguments, that he's not in possession, and the Commonwealth certainly didn't prove knowledge. I mean, in order to say that he knew that the car was stolen, they would have to have evidence that he looked and saw that there was no key in the ignition. They can't impute that onto him.
Timing is close. It was shortly after the time the car would have been taken, all that. But let me ask you, one of the things that troubles me about your argument, just see where we go, it is a common problem. A group of kids go and break into a car and take off it, and they're joyriding. Yeah. Only one can be driving it.
Yes.
And if we say that, well, the people who are there with them, even though they know it's stolen and whatnot, don't possess it because they're not driving, we've got a problem.
The case law says that presence as a passenger alone without more does not mean that the person has received stolen property. There has to be some evidence of a discussion or something.
Well, a lot of those cases, though, seem to me to be about what does it take to infer knowledge that the car is stolen. That's what kind of evidence you might need to infer knowledge that something is stolen is understandably going to be very different from, well, what does it take to infer possession?
I would say the opportunity to exercise dominion and control, possession with any other crime.
If that's a problem, isn't it up to the legislature if we have a problem with 4 people being in stolen cars all the time and only one chargeable under the statute, then the statute needs to be changed. It's a policy decision.
Absolutely. I don't know how they could prove.
Explain to me that I take it that the crime of using a motor vehicle without authority was not charged here.
It was not charged.
Just receiving a stolen motor vehicle.
Just receiving a stolen motor vehicle. Some cases where it was found that the defendant possessed the vehicle. There was evidence that he had driven the vehicle previously or that he had the car keys on him at some point, but there was nothing in this case.
And larceny wasn't charged either, was
No.
it? No. And
Larceny
larceny
was
might
not.
have been easier to prove, a joint, maybe, because he's in the front seat and it's a popped ignition and it's
was not a
shortly
popped
after.
No popped ignition.
I mean, well, it was going without the keys, excuse me. I don't know how you do that, but I wish I did, trying to forget the keys, but.
You invoke
but-
Harry Potter's,
Yes,
what you do.
But they might have been able, on a joint venture theory, to have proven larceny, but
Now, the Commonwealth said something at pages 16 to 21 of their brief that persuaded the appeals court that the evidence was sufficient here because that's all they cited in their 128. So what's wrong with what's on pages 16 to 21, which we're going to hear about in a minute, in spades from your brother?
Well, the Commonwealth based their contention, their whole argument, on probably 5 points. That the Commonwealth, they indicated in the brief that the Commonwealth was not required to prove the defendant was the driver. That is true. And then I would argue that the case law says, as a passenger, you don't have to prove that. They, in the appeals court as well, seems to be focusing on two things. One is that the defendant fled the scene. I mean, of course, I'm arguing that he was never in the vehicle. There was not enough evidence to put him in the vehicle, but that was a credibility issue for the judge. But they're arguing that the defendant fled the scene and that the defendant turned around real fast. So there is cases out there that say that just consciousness of guilt alone cannot warrant a conviction. So in order to bring them over that hurdle, they're basing everything on just the person turning and looking. I mean, there were 4 people in the vehicle. We don't know why he turned around.
Consciousness of guilt alone doesn't support a conviction in general.
Yes.
But consciousness of guilt is very important evidence in terms of an inference, what inferences can be drawn from the other facts. He was in the front seat, he turned around, shortly after his car stopped, he gets out, he runs, would tend to suggest that, yeah, he does have something to do with this. He's not just, been picked up after someone has stolen and is clueless as to what's going on.
Well, I don't think they ever proved that. I mean, they don't have a relationship. They never introduced evidence about the relationship of the parties, whether they were friends, whether they just met.
They never
It could have been a
apprehended the
hitchhiker.
others, so we don't know who the others are. Is that correct?
Absolutely,
Okay.
and I think in past cases, the court has focused on whether the relationship of the parties, when the person could have gotten in the vehicle. I mean, if they were close friends, maybe this person would have known that this was not his normal car. We don't know where these people were coming from,
Mr.
where
O'Brien,
they
let
were
me
going.
ask you this. I take it was an unmarked police car, correct?
Yes, it was.
At some point, did the police activate blue lights?
Um,
I mean, what caused the vehicle to stop? I know there were twists and turns and so on, and they pulled behind a 3-decker house.
Nothing.
But
He never.
did the unmarked police car follow into behind a 3-decker house?
Yes.
Okay.
But there's
so
no test.
let's assume that you assume it's police, and let's assume you're carrying marijuana. Carrying marijuana.
Yes,
Not
or you
unlikely,
have a-
or you've got an open six-pack, or I can think of all kinds of
Or
things.
you have a warrant or anything. And there's no evidence that maybe they were driving along for the night. I mean, it had been 7 hours since the car was stolen. We don't know exactly what time it was stolen till the victim saw the car, until it was spotted by the police. That 7 hours have gone by. They could have been driving all along.
Well,
and
I'm just trying to probe whether this was consciousness of guilt of what. I mean, it would not surprise me if there were some other challenges that this particular defendant didn't want to have confronted by any adult.
And the driver could have said, you guys, I have something to tell you, right when the police came upon them. This is a stolen car. I'm out of here. And
Could you go through the sequence again for me? As I understand it, that the officer in the unmarked car took notice of the vehicle because it pulled out quickly from a...
He did, Your
corner.
Honor.
Now, right, that's where we start.
yes.
All right, so we're driving along.
He followed them. He ran their plates. It didn't come back initially as stolen. So he was following behind them. They
And this is the middle of the night sometime. We are
Yes.
3 o'clock, 3:30 in the morning.
Okay, then what happens?
Then they were driving along. The officer continued to follow them. Didn't note any suspicious activity except for them pulling in front of them. made approximately 6 turns, and at some point, it
So
doesn't
the
say...
car's not speeding at this point, it's not
No.
invading,
No.
But no, as I...
Can I finish this?
Yeah,
for a
no,
second?
it's on this question. But the 6 turns, as I understood it, were in part to pick up and drop off people.
Right,
Yes.
that's what I was
So the
getting
6
Yes.
turns aren't just 6 turns to evasive action. They were 6 turns supposedly with a purpose in mind.
The officer testified, I don't know how he would know this, but he said that they stopped to pick up this passenger. The passenger asked to give him a ride home. He wasn't privy to any conversation, but that was his testimony.
But there
at
were
trial.
people getting in and out of the
This
car
person,
during the
absolutely.
course of the 6 turns.
And there
So
was
they
no
had a purpose.
testimony that they were racing, trying to get
Were
rid
there
of
other
the
people
car
getting out, or
behind
just the
them.
one person who got in?
One person got in and one person got out on the passenger side, which I don't know if it was the defendant or not, but the officer testified that person in the passenger's seat, whether he meant the passenger side, the passenger seat, got out and ran, then the rest of them, dumped the car and ran. So,
Well, how many stops did they make before? Did the car make before it stopped and everybody fled?
2 stops. One to pick up somebody to give him a ride home. That was what the officer testified to. And the other one was to drop off whoever was the person who ran, the white male who was in the passenger side. The person they had picked up to give a ride home stayed in the car, and he ran with the others.
Ms. O'Brien, as I understand it from the Commonwealth recitation of the facts, and I haven't read the transcript, at some point the police block a street. The car has to come to a stop, right?
Yes.
What was the basis of the police blocking this car?
Well, I think he followed them into that area in front and back of the 3-story house, and when he saw them get out, he blocked it and then backed up, got back in his vehicle, and the chase
So he didn't block
ensued.
the car in the sense of pulling in front of the car so the car couldn't proceed. The car stopped and he blocked the exit so the car couldn't get out.
Yes, that was my understanding of the evidence.
But the people left the car at that
The
point.
people had left the car,
They stopped
so-
the car and they left. Now, let me get
But
the
wait,
sequence
it,
again.
it says when the, I don't know, it just says when the police, Toyota pulls into a street, when the police vehicle blocked the street's entrance, the car pulled behind a 3-decker house.
Yes.
So that sounds
So-
to me as if the police have blocked the street.
Yes, there's no evidence that there were any lights or anything. There's evidence that they followed them there and blocked. There was no testimony that these people tried to get out, or that was why he kind of pulled behind them. It was a one-way, or it was my understanding of the
But the
evidence.
Commonwealth then says this sequence that I've just told you, this sequence allowed the judge to reasonably infer that the juvenile and the driver were acting in unison to avoid the police.
I don't see how that's possible, Your Honor. I understand
Well,
that's their argument, and the appeals court obviously agreed with them, but without being privy to any conversation of what was going on in that vehicle, plus the fact that a passenger, someone in the passenger seat, which the police officer said it was the defendant in the passenger seat, left before they were blocked by the police. I don't see how that could be imputed onto him. And there's a case which was actually cited in the Commonwealth's brief, Commonwealth versus Campbell, where there are 3 people in a vehicle, and the appeals court actually reversed the conviction for the 2 passengers. These people in a vehicle got into an accident, and everybody got out of the car and ran. So they said that even though there was evidence of guilt that everybody ran out of the car, that wasn't enough to find these 2 particular passenger defendants guilty. The driver was ultimately
Could you refresh my
convicted.
memory? The car stopped, the defendant got out, the car started up again, and then a short time later it was blocked, it was trapped.
Yes.
But the defendant got out of the car, and then the car had proceeded a further distance.
I think it's unclear exactly from the record whether it was the defendant. The officer never specifically said this defendant. He said he didn't say front seat passenger. He said the passenger front on the passenger side. This is the way he put it. Got out. So it's quite possible that was the defendant. Nobody ever clarified that on cross-examination, but it's quite possible. It was a white male pass on the passenger side.
But how did the officer identify the defendant as the person he saw in the car? What did he say he saw that enabled the officer sometime later to identify the defendant who was walking down the street as the person he saw in the car?
He said that when the person turned around briefly, he was able to identify that as the person. He didn't identify any article of clothing. He didn't and actually 6 months prior, he said he wasn't sure that that was the defendant, but nothing is mentioned in his police report about this defendant.
So the basis of the identification is the fact that the passenger in the front seat turned quickly and saw a vehicle
Yes.
behind him.
Yes.
That's it.
That's it.
All right. Now, when they what was the sequence? Did the defendant supposedly turn and see the police officer, and after that, did they then stop and pick up this person? Or had they picked up the person before the defendant allegedly turned and saw the car?
I could be wrong, but I don't believe the record is clear in that. I think the officer's testimony was at some point they picked up another individual who asked them for a ride. But that's what, essentially, I would argue, what the Commonwealth is basing the ability to convict this individual was the fact that he turned around and that he ran. Those are the only two things they really have to impute possession, knowledge, and there's no
The fact that he
intention.
turned around and he ran, but we don't know whether he was the person who got out of the car before the car stopped
don't.
and ran, or the person who got out when the car was abandoned.
We don't.
Why don't we know that? The person that got out of the car before the car continued on its way, did anybody ever testify where that person went?
Over a fence, but we don't know whether that was supposed to be the defendant, who he was later found 50 to 75 yards away. The officer never said that that was the same person. He just said someone on the passenger side, and nobody asked him to clarify it, so.
Now, this was a bench trial, not a jury trial, but could we say that there was a lack of evidence to support the verdict on the issue of identification?
Absolutely, and that's what I've argued in my brief, that, and even if we do, I argue that there's not enough to put him in the car, but even if we do put him in the car, there's still not enough on all three elements. No intent to permanently deprive. If he was running away from the car, I don't see how he could want to permanently, or deprive, not permanently, but deprive the rightful owner.
Well, at that point, he's been caught. I mean,
Might have intended it earlier.
Was anyone else apprehended?
No, nobody else. So that's why they don't know the relationship between these parties. They don't know when they met. It could have been a hitchhiker.
Again, and I do appreciate what appears to be the Commonwealth's very thoughtful, careful description. As I understand it, he didn't go over the fence. He went behind a fence and then started running.
Okay, then that's
So
probably...
it's not clear that this man got out of the thing and started running immediately.
No, I believe the testimony was that he started walking and turned and then started to run. So, again, we don't know what he's running from because he knew it was stolen, because, as Your Honor suggested, he could have had drugs on him.
If this is an unmarked car, and is this police officer in uniform?
There was no testimony whether he was or
If
wasn't.
this is an unmarked car, it's 3 o'clock in the morning, and somebody is...
And I would argue he's probably
Coming after
following
you.
relatively close if he's running the plates, so they could have said, who's this guy? That's a real reason to turn around and look to see why somebody is tailgating you, especially since they weren't an unmarked car.
Thank you, Mr.
Thank you
Bryant.
very much.
Mr. Steinfeld?
Thank you, Madam Chief Justice. May it please the Court, for the Commonwealth, my name is Ken Steinfeld. And I would like to begin by giving not my version of the facts, but what I believe the facts to have been from many, many hours of study of the transcript, which I admit is not the most coherent. It does not flow as a perfect narrative. But my understanding is that the following occurred. Officer Wolf was driving down Essex Street when a car pulled out of Sheridan Street on his left at a fast rate of speed. He followed this car a ways down to Chestnut Street. While they paused at the intersection of Essex and Chestnut, the juvenile turned around quickly, looked to see whether there was, the officer said, he glanced behind him to take a peek and see whether someone was behind him.
how did the officer know?
How does he know what's in the juvenile's mind? I mean, how is that testimony even admissible? Why?
Well, from the, I would argue from the tenor of the gesture, from a head spinning around quickly, and then as soon as eye contact was made, the officer said he saw him clearly for 2 seconds, and he...
Was there testimony that eye contact was made?
not eye contact specifically, but that he could recognize his face, and that as soon as the juvenile saw him, which I presume eye contact, perhaps that's not a reasonable inference from the record, I think it is, turned right around immediately, and the very next thing they did was take a right.
And then they stopped and picked up the passenger.
Right.
So
Is this evasion? I mean, this...
No, you
this
see,
is-
I would argue this is positive evidence of the reverse. I would argue that they drove perfectly well and normally to try to convince the car behind them that there was nothing untoward going on.
And these are a bunch of kids who've just stolen a car.
Yes, and they are afraid that the guy behind them in an unmarked Ford Expedition might be a police officer.
Why?
Why would they think that?
Why?
Because it is
When I am driving in the middle of the night and I see somebody close behind me who then follows me, one of the things, I mean, maybe you stop to see whether this person is going to follow. You have no indication that this is law enforcement.
Sure.
You might think quite the contrary, might you not?
Not if you're driving in a stolen vehicle at 3:10 in the morning.
But let's assume that the man who looked around didn't know it was stolen.
The juvenile?
Yeah.
I think he knew very well that the car was stolen, and I would be happy to discuss.
Fact finder could infer that knowledge at least.
Absolutely. You can infer it from the recency of the theft to begin with.
7 hours before?
Right. And there are many, many cases that hold that much longer periods of time one can still reasonably infer
For the passenger?
knowledge for a passenger. For instance, the Johnson case, which is in the brief at 7 Mass Appeals Court 191, the car had been stolen, quote, less than a month before, and the court upheld the reasonable inference. I've also...
Of what?
Pardon?
What was the indictment in that case?
Well, that was for... It was either for possession or for theft of a stolen car. I'm not sure. But the...
Well, there's no keys in it, so he must have known.
Right, there are no keys. That's another one of my... Actually, I have 7
that
reasons...
the thing was stolen.
Well, may I
Pardon me?
ask, how do we know? I mean, do we know the make of the car and whether a passenger could see the keys or
No,
not?
we know-
Some cars you can, some
Right.
cars you can't.
My Honda, I will just tell you, I can't even find the keyhole unless I put it in real soon when I shut that door. It's so dark. I don't mean to be frivolous, Mr. Stein, but the notion that you can see that there's a key there does not comport with one if it's a Honda. Now, if it's something else which has the light on all the time, I don't know about that.
Well, the only evidence was...
This is a Toyota, right?
Yes, a 1991 black
Oh, no.
Toyota. There is absolutely no evidence about the interior of the car other than it was found a mess.
So if the Commonwealth wants to make an inference, not unreasonable, that surely you saw that the key wasn't there, wouldn't the Commonwealth have to show that you could, in fact, at 3 o'clock in the morning...
Well, as Bill Belichick, the Patriots coach, liked to say, the record is what it is. I can't make it any more. Certainly, at a perfect trial, you would have evidence about the sightlines.
It's not a perfect trial. It really
Right.
is whether the Commonwealth has met its burden.
And what is the evidence on possession and control? Even if we get over, even if we assume that the juvenile knew it was recently stolen.
Well, first of all, I think the best evidence of that is the moment when the juvenile turned, saw that there was someone behind it. It might have been the police. It might have been, as the Chief Justice mentioned, the possibility, someone else who was after them for some other reason. We don't know.
I would be
Maybe
very
it's a-
persuaded of that if, in fact, at that point, the car took off. But the fact that it didn't take off
Suggests
tells me
to
nothing
the
about
opposite.
that quick glance at all.
Maybe they
Well,
thought it was a rival drug dealer, and they were picking up pals along the way, so they'd have more against them.
But the inference that I asked the court to draw need only be reasonable and possible. It does not need to be compelled. The first thing that the car did after he turned around was to take a right. Then it proceeded to make 5 more turns.
But it made
But-
a right and
but-
then picked someone up. It didn't,
Well, the test...
it
excuse me.
didn't make a right for any evasive purpose. It made a right, and then I guess it stopped in order to pick up the passenger.
Yes, it did.
So it wasn't trying to get away from the police.
No, it was trying to drive safely and carefully. And this, I think, goes very strongly to the possession aspect, that the Commonwealth showed that the juvenile had the power to control the direction of the car. I think it's a reasonable inference when he turned around and saw the officer, or the person in the car, excuse me, who was Officer Wolf, there's a guy behind us, turn here.
Well, how about, I mean,
Is there
I
a
take it that the passenger, there's nothing in the record, but passengers do sometimes look in the rearview mirror.
Right.
And there's nothing in the record to suggest how long, he may have seen this car come out of nowhere, correct? I mean, the streets are empty more or less at 3 a.m. in
Right.
the morning, come out of nowhere, and he says, I think we're being followed. Neutral statement. Passenger turns around and says, looks like we're being followed. Why don't we see if we can shake them? Right?
That is one possible thing that a juvenile could do in that situation.
No, but I'm just saying, all of that is neutral, so you want to shake them.
Pardon me, all of that is what?
Is neutral in terms of whether it's consciousness of guilt. So he says, let's make sure if we're in fact being followed. We don't even know if we're being followed. Maybe this car. So we turn right, and guess what? The car follows. And he says, well, why don't we slow down and see if the car will pass by? Sometimes cars turn right, and no, he slows right down behind them. Well, let's make real clear, like when we stop and pick something, well, how did we know what?
Well, the evidence was that the car stopped, and this was after the juvenile had turned around. The car stopped, and the officer testified. He did not testify as to the foundation of his knowledge, but he said a black male asked for a ride. One could reasonably infer that he heard it, because he testified that he was about 10 yards behind the car.
Well, he may have.
He may have inferred it just because he's...
Well, he may have been, I don't want to say, but, the functional equivalent of hitching a ride. He may have signaled that he was looking for a ride.
Right. Right. I think it is as possible, if not more, that this was not planned. It was just giving a person a ride. Perhaps they knew the person. But I'd like to return to the possession aspect, because there's one thing that occurred to me that is not in the brief. When the officer...
Excuse me, let me just ask you a question. This is 3 in the morning. How many people are out on the street who the people in this car happen to know? I mean, doesn't it seem as if they're picking up people by prearrangement so that they're not just making turns helter-skelter?
Well, there's nothing in the record, and I frankly don't know why they picked up this male.
Wouldn't that be a more reasonable inference, that they made the turn because they knew this guy was going to be there and they were supposed to pick him up?
Yes, and I think that favors the Commonwealth for this reason. When the officer stopped the juvenile on the street, the juvenile told him that he was coming from his aunt's house. And I think that's crucial, because that point where that conversation occurred was 50 to 75 yards away from where the car had been abandoned. Therefore, the car was abandoned within walking distance of his aunt's house. I think it's perfectly reasonable to infer from that they were driving to his house, and therefore the juvenile had possession of the car to the extent that he could control its direction to his house. And there is no map before the court, and I would be happy to submit a map from the Engineers Department of the City of Lynn.
Are we not piling inference upon inference at this point?
No. Well, I think that's... When you have this kind of a situation where there's only one person arrested who doesn't take the stand, I argue that it's merely circumstantial evidence that tends to prove. There are a lot of inferences that one has to make, but I don't think it reaches the level where we're piling conjecture upon conjecture.
Mr. Steinfeld, I have a problem with part of your argument. And part of your argument is that they were driving properly, and therefore there's some negative inference to make on that. So one way or the other, the Commonwealth would have stopped them. If the car sped up, maybe I shouldn't say stopped them, but would have had some suspicion. If the car had sped up, you'd point to that and say, look, they drove away fast once they saw the police. But here you're saying, no, they didn't speed up. They drove properly, and because they drove properly, there's some negative inference to be drawn from that.
Well, I think, well, my claim is that it's not unreasonable to think that they did that intentionally to keep the suspicion level of the person behind them low.
What would the rule be if we agree with you? In the future, what are we telling the police? That if you drive behind a car and it drives fast, you've got something going, but if they drive properly, you've also got something going. To me, that's a hard one.
Sure, but I think based on the circumstances and the timing and the fact there are 4 juveniles in the car, taken all together, of course you can't say when a car is proceeding normally, one should never follow them, just as you should, when a car is speeding, the police don't always follow that car. I'm just saying that it's a reasonable inference that they did that responding directly to the juveniles having turned around and seen the officer.
You said something a minute ago that there was only one person arrested and that person didn't take the stand, therefore, and then I don't think you got a chance to answer, but what does it have to do with anything that there's only one person arrested? I mean, either there's enough proof against that person or there isn't.
Sure, but the question was whether we are piling inference upon inference, and I'm just saying the Commonwealth presented what evidence it had, and then we asked the judge to draw all of these inferences from that. I'm just saying the testimony was limited to the Commonwealth's case. I'm not making any comment, of course, on the juvenile's failure to testify. I'm just saying because that's what we had, we do have to draw a lot of inferences. I don't deny that.
If what you have isn't enough, that's just the end of it.
Oh, sure, but we argue strenuously that there was more than sufficient evidence from which any rational trier of fact, viewing the evidence in the light most favorable to the Commonwealth, could have found the elements of the case.
Can I ask this question that's puzzling me? You've studied the record. I've only studied the briefs. When the officer saw someone, the first person who left the car, this is before the car was stopped and abandoned, right?
Right.
The car stopped, someone got out from
Right.
the passenger side and began walking behind a fence, and then the officer said he proceeded to run. Was that the defendant?
No. I think that the officer did not say yes or no. He said a young male, I believe was the phrase that he used, got out of the car. Then after that person got out and went towards the fence, then the car whipped around behind the 3-decker. I think that it would have been much more reasonable for the officer to have said, and only natural for the officer to have said, and the juvenile got out of the car. And I think that's reasonable because the officer testified at trial that when he saw the juvenile walking on the street just a few minutes later, he recognized him as the boy who had been in the car.
But we don't know who got out of the car.
No, but I would argue further that it doesn't matter whether he got out then and there and took off into the bushes or he was with the other 2 who went behind the triple-decker and then took off. They all abandoned and fled the car, leaving it in a messy condition with the ignition on,
Maybe
the windows
they all
down.
had guns on them and they didn't want to be stopped with guns on them.
That is a possible, reasonable inference. There are many possibilities, of course.
When the juvenile was ultimately stopped, he didn't have gun or drugs or anything else. No other contraband was found. No other charges were brought.
No, there was nothing. The only bit of evidence from that exchange that I think is important, the juvenile did give his proper identity. He said that he lived in Beverly, and I also want to point out that the car was stolen in Beverly, which also helps the notion that he directed the car from Beverly to his aunt's house in Lynn. But he lied to the officer about having been in the car. The officer asked him, were you in this stolen vehicle over there? And he denied having been in the car. And I think that is very important consciousness of guilt evidence.
Given the shakiness of the identification, we can't be sure that he lied.
The shakiness of the identification occurred 6 months previously at a motion to dismiss hearing. On this point, I think that if you take it in the light most favorable to the evidence, you must believe that the officer identified the juvenile as having been in the car. He was unequivocal at trial that it was the person, that the person he saw whip his head around was the same person. There was no doubt in his mind whatsoever.
Your testimony about the distance that the police car was behind the car?
Well, it said there was, at one point, right near that time, that he was 10 yards. And the juvenile's counsel asked, well, was that 10 yards from the seat to seat? And the officer, no, 10 yards from the front of his car to the back of the Toyota. And I would submit that that is sufficient time. And the officer's testimony was unequivocal. So the fact that he had not been sure on previous occasions, That obviously goes to the weight of the evidence.
So he's making an identification from about 35, 36 feet away in pitch dark, 3 a.m., and just like that, movement.
Well, pitch dark, I'm not sure. There was
But
no...
was there testimony about the lighting conditions?
Not at that intersection.
This is the Commonwealth's burden. There's very little evidence here.
Sure, but we had the police officer saying...
You can present testimony about lighting. The police know about lighting, and you can have testimony about all of the distance at the exact point of identification.
Of course, but I think viewed in the light most favorable to the evidence, there was enough based on the officer's testimony. It presumes that there was adequate light. He presumably would not have said...
There's no presumption of adequate lighting.
Well, if you can see someone at 3:10 in the morning in a car in front of him, or if you say you can, one can only do that, I would argue, if there is sufficient lighting for you to do that. I mean, we can't see in the dark. I think that's...
Well, presumably the
obvious.
officer's headlights were on. That would probably be the main source.
The headlights were on. There were lights there. Maybe the lights, there was...
There were
some
lights
reflected
there?
light.
I just thought you said there was no evidence as to the lighting.
No, there was I believe there was a traffic light, but I don't know about whether there were street lamps. There was no evidence as to that.
Was the identification made at the traffic light? Was the
Pardon me?
identification made when the car was stopped at a traffic light?
I'm not sure that I understand the question. The car was not stopped at a...
You said that there was a traffic light, and that helped the officer make the identification.
No, I'm saying that it was at that intersection that he saw him. The car was pulling up towards the intersection of Essex and Chestnut, and right as the car approached that intersection, that's when this key moment occurred that he whipped his head around to see whether someone was following him.
Thank you, Mr. Steinfeld.
Thank you very much.
We'll take a short break.
All right.